Yes, yes, it's the most perfect gambit ever. How many grains? Yeah, what? Court rising available.
Yes, my lords. So, what I was saying before the short adjournment was that because of the substantive reproduction of the old annexes 12 and 13 within the new Annex 7, parts 3 and 4, there can be no substantive change to the meaning of the term designation. Therefore, the judge below did not fall into error when he based in part his understanding of the term designation upon that which occurred within the old regulation. So there's no error there, we say. The next point is that the term designation from the old regulation expressly stated that it means the name used at all stages of marketing, and in the new regulation, when talking about sales description, it talks about the name under which a food is sold. And so therefore, yes, designation is wider than sales description, but only in the sense that it is wider because it refers to all stages of the commercial life of the products, as opposed to just a limited stage of the limited point of the commercial life of a product. But there's no difference in the type of things to which they are referring. They're all referring to names of products. And when you look at those two regulations and the regulations and directives to which they refer, all of the things to which they make reference are, in essence, generic names. And we saw that in Article 5.2 and in Article 17.4 of the respective directive and regulation, that there's a carve-out, an express carve-out, so the name cannot be a trademark or something else that is protected.
It's not actually what it says. What it says is you can't substitute a trademark for the name.
Yes. But the way in which I'm putting that forward to your lordships is that therefore the name cannot be a trademark. And that seems to be something that you have to read into how you understand the term name is going to be used, and that therefore feeds into how you understand the term designation. And in my submission, that if the relevant regulation under which we're disputing the matter today wanted to include things like trademarks within the ambit of the term designation, you would have needed clear, express language to that effect. Because if you read everything else, it appears quite clearly in my submission that trademarks are excluded. And therefore, we say that the decision below is correct because the judge was correct in holding that post-milk generation as a registered trademark is not a designation and therefore is not caught by point 5 of the part 3 of Annex 7. Therefore we win, basically, on that point. Now, moving to the Tofu Town decision.
Well, before we get on to that, what if the registration were for Oatly milk?
Right.
On your thesis, that wouldn't be cool.
No, my lord. I have 2 points on that. The first point is that post-milk generation has been through a critical examination of the trademark registry and the High Court, and it has been found to be an acceptable trademark because it is not descriptive and it is not deceptive in any shape or form.
Oatly milk wouldn't be descriptive.
No, but then that brings me to my second point, my lord. If one was attempting to register Oatly milk as a trademark for, shall we say, the product of oat extraction, i.e. non-dairy products, it is perfectly foreseeable that there would be an objection raised that it would be deceptive.
What's that got to do with it?
Well, it's got everything to do with it. It wouldn't be a trademark then.
No, but on your what you're postulating is that there would be an objection under section 3, subsection 3b
Yes.
of the UK Trademarks Act 1994. How can that be used as a basis for construing the regulation?
Because what I am saying is a narrow point is that if you have an acceptable trademark, it cannot be a designation. And on your hypothesis, my lord, you don't get to the stage of having an acceptable trademark. Because Oatly milk for non-milk products is not an acceptable trademark. So it's an argument being used against me upon a false basis, is my submission. You can't get Oatly milk as a trademark for non-dairy
What if it was
products.
erroneously accepted?
But my lord, then, the point is it's a bad trademark. This trademark, post-milk generation, has been through the mill and been found to be a good trademark. There's a certificate of contested validity.
Well, it's been contested under section 3.3b and section 3.4, yes.
And also section, by necessary implication, 3.1, because no objection was made.
Well, no objection was made, but therefore there was no issue and no decision.
I accept that. But the point is that the registry never raised one, and nobody else has ever raised one.
So what?
Well, my lord, that's prima facie evidence that the mark is valid with respect to
Well,
section
you've got the presumption of validity by statute, of
section
course.
72, yes.
Yes. So what?
But what I'm saying is that with
That would apply if Oatly milk were to be wrongly accepted.
I accept that, but then you still have the fundamental point that it's a bad trademark. Because, my lord, otherwise you're going to give any example that's a bad trademark, you say just because it's registered or asserted to be registered or registrable, that it therefore escapes the provision. That can't be right. That's arguing, basically, to say that there's a prohibition against the word black, and if wrongly I manage to register the word black, we can ignore everything.
All right.
So, my lord, that's where I started, or ended, which was namely, I say because it's not a designation, it doesn't fall within the ambit of the prohibition. My lord, I was then going to move on to Tofu Town. Is there anything else from anybody? Sorry, my lord, are you just about to ask a question? Sorry, I thought you were just about to ask a question.
Well, I'm just still thinking about Oatly milk. What if it was relied on as being a brand name without registration?
I'm terribly sorry, my lord, I didn't quite hear.
What if it was being relied on as a brand name without registration? Because, of course, when you look at Article 5.2
Yes.
of the 2001
Yes, I know what
directive, it refers to trademark or brand name.
or brand, yes. Yeah, I accept that. Well, that works one way around the point about registration and whether or not it's been through the mill and therefore been approved as or accepted as an acceptable trademark. If you merely assert that it's a trademark, which is in essence what you're doing when you're branding, point would be...
Take the analogy of the American practice, which fortunately we don't have in this country, and I don't even know if it's as prevalent in the US as it used to be. But in the US, it used to be quite common. If you had a registration, you would put R in a circle next to the subject to the registration.
Yes.
If you didn't have a registration, but you still wanted to lay a claim, because under the Lanham Act, registration is actually only evidence that it's a trademark, you would put TM.
TM, yes, as a superscript after the appropriate indicium, yes.
So what if it was Oatly milk TM?
My lord, well, the trouble with that is that it's not a matter I've thought about deeply beforehand. It falls prima facie within the wording of Article 5.2, as your lordships pointed out, because it uses the term branded. My submission, I think, would then fall that it would still fall foul, because in that case, it would be deceptive and probably, well, I then have to say that, that's a possible number way around it, is that it would fall foul of point 6 in part 3 of Annex 7 of the new regulation, which is any other presentation. And that point 6, in my submission, is a very wide catch-all phrase which is deliberately designed to catch things that are not designations, because designations are covered by point 5, and yet it would still be claiming falsely, suggesting, or what have you, that it's a dairy product. That's the wording in point 6. So I can still argue that your example, my lord, of an unregistered trademark, which is a mere brand indicated by, for example, the TM superscript, I can still argue that that is not a designation, and that's consistent with my interpretation of Articles 5.2 and 17.4, but would still be prohibited because of point 6, which is a sweep-up catch-all safety net, under the characteristic that it's any presentation, which is the final wording of that point. Does that answer, at least to your current satisfaction, my lord?
Well, it's an answer, thank you.
Right. My Lord Snowden.
Can I have a go? Can I start with Article 5 of the old regulation? And I'm just trying to understand what you place. Obviously, you place a lot of reliance on this. My understanding is that Article 5.1, which is page 33, the name under which a foodstuff is sold shall be the name provided for it in the community provisions applicable to it. So, in the current case, milk. That's the foodstuff, that's the name provided in the community provisions. Yep, with me so far?
My lord, yes.
Good. Now, what sub 2 is dealing with, I thought, was a situation where somebody's trademark had become so synonymous with the product that they might be tempted simply to try and sell the product under that trademark. I mean, it's not a foodstuff, I know, but things like Hoover became synonymous with vacuum cleaner. It's that sort of thing. So, I mean, I can't think of any trademark that's synonymous with milk, but I mean, for example, you could have, Mr. Kipling's, which is synonymous with cakes. Now, I thought what sub 2 was dealing with is what it's saying you have to say it's milk. You can't say just this is Mr. Kipling's if that was synonymous with milk. So in other words, you've got what it's saying is you can't take the actual name under which a foodstuff is to be sold according to community provisions and instead put your own trademark in just because you reckon you're so well known in the market. But why does that mean that when you wind back to designation, meaning the name at all stages of marketing, for example, the designation couldn't, in the scenario I've given, for example, be Mr. Kipling's milk? Because it would comply with 5.1, it wouldn't infringe 5.2 because you're not substituting Mr. Kipling's for milk, but the designation would be, wouldn't it, Mr. Kipling's milk?
Well,
It would be the composite thing, wouldn't it? And the fact that it included a trademark wouldn't stop it being a designation.
my lord, I mean, I think this suffers again from the problem that in that factual scenario, if I've understood your question correctly, the trademark has actually lost its capacity to distinguish goods of the same nature coming from different trade sources, and therefore it's no longer a trademark, it's a bad trademark. But the other way around is to say that it's still not a designation because it's used in a trademark.
Well, okay, hang on a second. I mean, a classic trademark is, as we've all been talking about, or brand. It says brand name.
Yes.
So let's take it away from milk for a second. I mean, let's talk about cakes.
Yes.
Which I assume are a foodstuff, and I assume that somewhere in the community legislation that somebody says cakes have to be called cakes. I mean, I'm just.
No,
I don't want to get too far into specific trademark. What
Yeah.
I'm just trying to do is to understand how you work back from. So you try and work back from 5.2
Yes.
through 5.1 back into the definitions to
Yes.
arrive at a result. And
Yes.
I'm just wondering if that's really, I think,
Well,
questioning with you, is that really what Article 5.2 is about? 5.2 is just saying you just can't not use the community provision name, milk, by putting your own trademark in, no matter how well known you are for that product.
If I've understood your question correctly, then, as I said, my first answer is it wouldn't properly be a trademark, but my second answer, I think, would be, I repeat what I said to my Lord Justice Arnold, is that that would be a way of presenting the products which would be prohibited under point 6 with respect to the milk products. Because you see, the way in which the prohibition works in Part 3 of Annex 7 of the new regulation is that focuses upon a certain category of products, milk products. So I know you're trying to take it out of milk and moving it into something else.
All I'm not trying to go anywhere near the new regulation at the moment.
Right, okay.
I'm literally simply trying to test your
Fine. Okay.
your thesis, which under the old regulation solely depends upon reading 5.2 with 5.1 and then going back into the definition in Annex 12, I think.
Well, maybe the simpler way of dealing with it
Isn't that right?
is no trademark, brand name or fancy name may be substituted for the name under which the product is sold. Are you truly substituting the trademark for the actual name itself? Or are you actually trying to refer to goods of that sort only originating from one source, which would be indicated by the trademark?
Well, a different way of putting the same question is the example that I mentioned to Mr. Moody Stewart. What if you have a scenario in which the trademark and the name under which the product is sold are in fact one and the same thing, viz. Champagne,
Yes.
which is a name under which the product is sold, and it's also a collective trademark.
Yes, you're not going to like the answer to this question because I thought of that while you were putting it to my learned friend. With respect to champagne, in my submission, that's a bad example because champagne is a sui generis type of right, which over literally centuries has educated the public to mean a particular thing, namely it's a type of product that originates from a particular part of France. And so therefore, it's a very unusual...
But it's not alone. One can think of the other examples.
But all the GIs, which that geographical indications, that basically is, are all of that ilk. There has to be an education over many years of the public such that you move from some general understanding to some particular understanding. Take Melton Mowbray, for example, because that actually is the subject of a case that was before this court only very briefly, admittedly. But Melton Mowbray describes a particular type of pork pie, but you can only legitimately use it with respect to pork pies produced in a certain way within a certain geographical area.
Yes.
So
And the answer is what?
And the reason for that is because of, in essence, the particular education that has gone into the public with respect to that particular mark. So those sorts of GIs all depend upon massive education with respect to that particular product, with respect to that particular name under which they're sold. They are all, in essence, exceptions to a general rule. GIs otherwise don't get off the ground, because otherwise they fall foul of trademark law because they're generic.
What's, just for my education, what's a fancy name as opposed to a brand name?
My lord, I can't truly answer that because I think it's come from some other source.
Okay. But a brand name is...
A brand name is, as my Lord Justice Arnold said, is basically something that has been used to indicate a particular trade source but has not yet been registered.
Right. So you can't use that in substitution for the name provided for in community provisions for the foodstuff.
Yeah.
But why can't you use it together with? You must be able to use it together with. And doesn't that, in the name under which the product is sold, presumably?
But there's a difference between using it together with the generic term. Mr. Kipling's cakes are cakes that originate from Mr. Kipling, as opposed to saying that you can call all cakes Mr. Kipling.
Well, actually, I don't think it originates from Mr. Kipling. I don't imagine Mr. Kipling is busy baking.
But sorry, I'm using the term in the sense that there is a trade source that goes under and by reference to the term Mr. Kipling, not in this case, a particular person.
It's certainly sold under that name. I query whether it's... Anyway, but the point is the name, surely, is the name, not the collective. As long as you don't substitute the name provided for in community provisions, by your brand name.
You can do that.
Yeah, you can, and that's all that 5.2 is trying to stop you from doing. It's not saying that the composite isn't the name, i.e. the designation. It's just saying...
Yes. I think I understand. Yes, you're right, my lord.
Yeah.
I.e., if I've understood correctly, I cannot substitute Mr. Kipling for the word cake.
Correct.
But I can use the composite Mr. Kipling's cakes.
And that would be the designation. Because that would be the name used at all stages of marketing.
I would say that that's not a designation. Because I would say that the way in which the word designation is being used is as a term referring to a generic product.
Yeah, that's what I'm trying to test.
Right.
Because obviously Mr. Kipling's cakes is not a generic
No, exactly.
term.
Exactly.
It's a much more, but you say therefore it's not a designation.
Correct. And coming back to my Lord Justice Arnold's point about champagne, it's not a generic term. Champagne is not generic.
Well, it is generic as between champagnes.
My lord, tell that to the Swiss who have been sued by the champagne houses. They can't use the term champagne upon wines that they've been juicing for 900 years. It's not a term that can be used by anybody outside of a
But
certain collective.
any producer
Yes.
in champagne
Yes.
can use that term.
And that's the oddity with respect to collective trademarks, certification trademarks, and GIs, that they indicate a grouping of people, not necessarily an individual
Well, exactly.
trade source.
Yeah, exactly so.
Yeah.
But so how do you fit collective and certification trademarks within your scheme? Let's move away from GIs.
Because each and every one of them depends upon a massive education of the general consuming public, such that they're in essence not deceptive, so therefore they're acceptable.
That can't be right for a certification trademark. So you can do that from scratch.
No, certification, that, yeah. But, sorry, the question originated with respect to collective goodwill, and in particular champagne. With respect to certification marks, well, there's tight provisions on certification marks with respect to whether they have any, for example.
But why does it depend on whether there's goodwill or not? I don't see why, in principle, you can't start a collective mark from scratch. You can say, here is my new mark, and this will be open to use by anybody who satisfies the following criteria. And that they may be geographical, or they may be in terms of ingredients and recipe. Think of Advocaat. Now, cases like Advocaat, it's worked the other way around. You've established the goodwill first, and then you can think about registration subsequently. But why, in principle, couldn't you do it the other way around? Why could you not start from scratch?
In particular with respect to a certification mark.
Well, certification is the easier
It's
example.
the easy example, yes. Well, with respect to certification marks, without going into the details, there are restrictions on certain things that you can or cannot try and get up and running as certification marks. There's
There are, yes.
restrictions with respect to geographical terms and what have you.
Yeah. But so what? I mean, we're trying to understand at the end of the day how to construe this regulation.
Well, we are right at the edge. I say I'm nowhere near the edge because certification marks, collective marks may well pose difficult problems. But with respect to a plain trademark indicating one trade source where the term is not generic in any shape or form or descriptive in any shape or form, I don't have to explore the outer boundaries. And I say that must be clearly excluded from the ambit of what is a designation.
All right.
Received a note from those behind me, and my Lord Justice Snowden, relating to your point about Mr. Kipling, the note reads basically that in that composite phrase, Mr. Kipling's cakes, the term cake is the designation, whereas the Mr. Kipling part is what I would say not part of the designation. But I'm not sure that takes us further than where we've been.
I mean that is consistent with your reading of Annex 12, paragraph 1. Designation means the name. You say name means and only means the name that the community provisions give to the generic thing.
Yes. Yes, the name, cake.
Yeah, and you say, but you also say, and have to say, I think, that 5.2 prevents a trademark from being a name.
Yes. So you can't say Mr. Kipling full stop when you're to mean cake generically.
And that's what 5.2 is designed to stop, because 5.2 is designed to stop people selling foodstuffs without using an acceptable name.
Yes.
To avoid some people who don't actually know what Mr. Kipling is.
Yes.
Buying something that would be labelled Mr. Kipling's, thinking they were going to get a hot dog or whatever.
Yeah, hot noodle or something.
Yeah. Anyway, all right. I think we've pushed this example about as far as I could conceivably push it. But okay.
And with respect to milk and all those sort of things, that's why you get in the new Part 4 under Annex VII all the detailed points about fat content when you're talking about skimmed and semi-skimmed milk and what have you, because they're trying to define the product and then give you a term that you can use in relation to that defined product. My lord, shall I go on to Tofu Town?
Yes, by all means.
My learned friend took me through Tofu Town, so I wasn't going to deal with it in detail paragraph by paragraph, but he did take you to paragraphs 31, 40 and 52, and those are the operative paragraphs which basically say that by the addition of a descriptive plant term, whatever it may be, soya or however, that does not save the use of the designation. Now, what's interesting there in my submission is that all of the examples given relate only to plant descriptors being added. None of them refer to trademarks being added. So that's one of the reasons why we say that tofu...
Except that soya too was a
I was
trademark.
going to come to that, my lord. But in the actual paragraphs, where they describe what is being prohibited, they all refer only to plant descriptors. And that's not the case here. Then, taking the point that my Lord Justice Arnold has just raised, soya 2 is a trademark. But what is not considered as a trademark is soya 2 tofu butter. There's no indication that that three-word phrase was registered as a trademark.
Just out of interest, how do we know that soya 2 is a trademark?
Because it's registered.
Lord's...
It's a matter of public record.
Yes.
Okay, so my follow-up question to the pair of you would be that the ECJ doesn't seem to have sort of
touched upon it.
I
No,
mean, there's
exactly. So what they have, they've listed...
We know that because now I know it, but you wouldn't know that from just reading the you wouldn't read it from just reading the judgment, which seems to be completely irrelevant to them.
Yes, there's 3 points there, I think. First, it is listed in the introductory parts, just as one of the things that were under discussion. Then, in the...
So, somewhere in the introductory part...
Sorry, let me just find it for you.
Paragraph 15.
Oh yeah, sorry, it's listed, but
You've
not
got that.
sorry, yes,
Yeah.
It's not said that it's a trademark. Yeah.
No, it's just listed as one of the things
sorry,
that have been talked about within the case.
Although it's not hard to pick it up, given that it's capital S, and given it's a fancy name.
My lord, yes, I've been asked before what a fancy name means.
Well, its usage you used to have under the 1938 Act, I think, or possibly the 1919 Act. If you look at old trademark cases, you will find that language used.
Yes.
Yeah, I'm not sure actually the capitalisation helps you very much, because plant
True.
is capitalised and veggie is capitalised and so is cream. So, anyway,
sorry.
Next point.
My lord. So it is mentioned there in paragraph 15.
Yeah, I get it.
But then, if you look at any of the operative paragraphs, and I mentioned 31 as my first one.
Yeah, it's never referred to.
It's never referred to.
No.
All of those paragraphs, 31, 40 and 52, I've just picked out 3, but there are others, but those ones were definitely where there's no mention of anything other than plants type references. Do you see what I mean? So therefore, in my submission, Tofu Town doesn't touch upon questions of when there's a trademark involved, because clearly when they're talking about how they reached their conclusion, they never included it in any of their reasoning.
No, but you can't work backwards from that and say, hey, so where we do put a trademark in, it's all right.
No, but this is one of the reasons why both myself and my learned friend don't rely very heavily upon Tofu Town. We say we only really adduced it because it's the only case on the subject, but it's not really relevant.
No.
Because it doesn't deal directly head on with the issue of trademarks, whether or not they are designations or not. But what you can see from Tofu Town is that in those operative paragraphs of 31, 40 and 52, when it's trying to give reasons for its final conclusion, it's only talking about generic plant descriptors, and those do not save the designation. And that's why this case is different, because in this case, with post-milk generation, you treat the whole together as a unified whole, and that is a trademark. And it's a trademark that has been held not to be descriptive by necessary implication, and it's been held actively not to be deceptive. And this is where I'm leading with respect to my second string, is that my first string is, of course, that post-milk generation is not a designation, therefore doesn't fall within the remit of the relevant regulation. But if it were a designation, then because of the findings of fact, which are not challenged, it's something that would be saved by the various provisions. Now, this then brings me to my Lord Justice Arnold's point about the exclusive nature or otherwise of, in Tofu Town, of the council decision. And this is where we have a difference of opinion. And it all centres on paragraphs 33 and 34 of Tofu Town. And it will come as no surprise to any of my lordships that I prefer the analysis that was advanced by my Lord Justice Snowden, and that is because I say that if you look at the decision, the council decision, and if you look at 33 and 34, those are all focused upon products and not characteristics of products. And to make good that point, if I might ask you to go to the decision itself, which is behind tab 1. Now, you briefly looked at recital 2, which is in essence setting out the various possibilities. In recital 3, it then says the member states must notify to the Commission indicative lists of the products which they deem to meet within their own territories the criteria for above mentioned exception. A list should be made of such products on the basis of the indicative lists notified. The list should include the names of the relevant products. So all of that is focusing upon particular products.
But I don't understand why that helps you, because in the second part of the exception, it's a characteristic quality of the product.
Yes.
So it's not characteristic quality in the abstract by reference to nothing in particular. It's a characteristic quality of the product, and therefore you have to know what the product is, and that's what the list does. It tells you what the product is.
No, my lord. In my submission, there's two different parts. There are products under the first part, and there are a way of referring designations that refer to a characteristic of a product. And those are different because what this is doing, council decision, is trying to form a list of actual products which, through long usage, have been educating the public that they are of a different ilk to dairy products.
Yeah. What it's trying to do, as I understand it, is it lists descriptions which have been traditionally used to describe products, the exact nature of which is known to whoever would read them as a consequence in the particular jurisdiction that you're talking about. The other way, so that's one way in which the exception applies. The other way in which the exception applies is where the designation, which for this purpose includes everything we're talking, it's not just the name, but it's the designation, is clearly used to describe a characteristic quality of the product. So it's either the description tells you exactly what the whole is, or the designation describes clearly a particular characteristic of the product. That's how I understand it. It's either or both.
Yeah, and you can find examples of both types in the lists. So I referred earlier to the example of cream or milk for spirituous pleasure. There's another one is cream-filled sweets or chocolates. For example, peppermint cream, etc. Cream egg. So if you come up with a new cream-filled sweet or chocolate, you are covered, and that's within the second part, because it can't be traditional, because it's new.
I accept that point, my lord. But the point being is that it's all by reference back to the traditional products. I mean, you have some very bizarre things here. Cream of tartar. That's potassium hydrogen tartrate. That only works because for 100 years, people have called it cream of tartar. It's got nothing to do with, you can't even eat it. Well, you could, but you shouldn't. Let's put it like that. It's a critical ingredient of baking soda.
Okay.
What's interesting under this example is that milk of magnesia is not covered.
That's not an agricultural product.
Well, not cream of tartar, my lord.
Well,
I mean, okay, there's a technical point there about being lees and wine, but it's not really considered an agricultural product.
milk of magnesia is a medicinal product. I think that's why that's not on the list.
Well, cream of tartar is a cooking ingredient.
To be sure, but agricultural products are pretty widely defined. Anyway, I don't think we need to.
No.
We've got enough mysteries in this case as it is without adding a further mystery.
But yeah, the only thing I say is that milk of magnesia is accepted usage, I would say, because of its cloudy look. It looks like a glass of milk. And you still find products, you just go into any common pharmacist and you'll find it nowadays.
Right.
But assuming you're right.
But we don't have to decide why that is so.
No, I have.
Is my point.
No, I agree.
Given that there's an alternative explanation.
My lord. Yeah.
Assuming you're right, and the list in the decision, the Commission decision, is not definitive of both limbs of point 5.2, the exception to in 5.2. Where does it get you? Don't you just aren't you just out of the frying pan into the fire?
No. The reason why, because I have to argue against the point that this is the definitive list that covers all except
I know, but assuming you've got over that and you're not bound by this list.
I then argue under the second part of the proviso to point 5 that post-milk generation is a term that would be understood as not relating to a dairy product.
Well, but surely the point is it would be, the finding is that, sorry, let me get the wording in front of me before I put this to you.
Just 1 second.
you only get out under exception 5.2 if the designation, quotes, is clearly used to describe a characteristic quality of the product.
Yes.
I thought the whole point about it was that there was a finding that it described the people who were likely to buy it.
Yes.
But that's not a description of a characteristic quality of the product.
No, in my submission, it is, my lord, for the following reason. Because if those people who have been clearly described are people who do not want to purchase anything that contains a dairy element to it, then the application of that mark to the product must be so as to indicate that it has no dairy component. That's how I get there.
And where did the hearing officer make a finding to that effect?
To the last limb, the second limb, no. To the first part, yes. And I say the second part of my argument must be a necessary corollary to the first part. It's completely implicit. Because otherwise, you couldn't make that finding with respect to the first part. This thing only speaks truly to those people who do not want to have a dairy product. Do you know which?
Can you help me on a procedural question? Was this a ground of appeal of yours to the High Court?
Sorry, which bit, my lord?
So, your primary ground of appeal in the High Court was to say that designation didn't include a trademark.
Yes.
Did you have another ground of appeal saying that even if it did include a trademark, you were within the proviso to point 5?
No, the way in which we argued it, that, so to speak, arose during the way in which the matter was conducted before the judge on appeal.
Well, can you help me then? How do you say that you are able to advance by way of respondent's notice a ground which was not part of your appeal in the court below?
Because we say it follows from a finding that is unchallenged. Because I'm saying that the second part of my analysis is implicit within the first part which was found below.
I'm not sure that's an answer to my question.
Oh, okay.
You were the unsuccessful party in the registry.
Yes,
You appealed to the High Court,
my lord.
and therefore any ground of appeal that you took in the High Court is available to you in this court, provided that it's either encompassed within the other party's ground of appeal or your respondent's notice. But if it's not a ground of appeal that you raised in the High Court, how can you raise it in this court?
The grounds of appeal before the judge is on page 96 of the core bundle.
Thank you.
And, my lord, you're right in the way in which it's being presented. You've just put it forward. So therefore, if you're going to shut me out for that reason, you shut me out for that reason.
Well, if there's an answer to it, then by all means give me an answer.
I mean,
Well, the answer would be presumably you'd have to just apply to raise it as a new point on appeal, and you'd say it doesn't arise out of any findings of fact, or at least you could only run it without disturbing the findings of fact made below.
Yes, it's the Vitol case, paragraph 34 from this court, VITOL, which talks about raising new.
Okay, well, there are other authorities on raising new points, but yeah. But, you know, in other words, I think the point is you can't go beyond the factual findings made below on any view.
Well, yes, I'm trying not to do that.
You'd have to say, you know, it's a point of law that you could run on the basis, of, but only on the basis of the factual findings that were made below. You can't start asking this court to make factual findings, which goes back, I think, to what my lord was putting to you. I mean, if you go back to the hearing officer's decision, which is
10, I believe.
yeah, I'm just trying to it's set out. Actually, it's like it's probably set out in the judge's decision. But okay, let's go back to the original one.
Are you going to the judge's decision?
Well, no, let's go to the original then. 33 at page 81 of the bundle, I think. I mean, what the hearing officer said is that I agree with the submissions that the average consumer will view the mark as an ironic way of saying its goods have moved, its, meaning Oatly's, have moved on from conventional milk and are for consumers of a post-milk generation. And then she says, i.e. those who no longer consume dairy milk. I have to say I have some problem with that, just as thinking that takes you home. I mean, why does that tell you the characteristic of that it's clear from that expression, post-milk generation and nothing else, that whatever it's put on doesn't include any dairy products or milk?
Well, because of the next sentence, my lord, which actually also addresses a point of the second ground of appeal. They will not be in such a hurry that they only perceive the word milk, ignore the other two words, and assume they are buying dairy milk.
Yeah, but I think one needs to read on into paragraph 34 to understand the sense of the reasoning, where the hearing officer says that section 3.3b is not directed at marks containing statements which, although inaccurate, have no bearing on the consumer. There must be actual deceit or a sufficiently serious risk that the consumer will receive so that their behaviour is materially affected. Average consumer will not be able to believe that the goods contain dairy milk and are therefore deceived because they do not.
I mean, this is, I think, Mr. Moody-Stewart's point that it may be that this is all in the context of whether it's deceptive or not, but does it clearly, sorry, whatever the wording is,
yes.
Does it clearly communicate describe the characteristic quality of the product? I mean, dairy-free or milk-free, I think would, at least on the current view I have of the world, which may change, would fall within this exception in the second part of 5.2, because the characteristic quality of the product is it doesn't. If you say milk-free, it means it doesn't have milk, because you're describing the product.
Yes.
Now,
whereas here you seem to have to go indirectly through the assumption about that the person buying it would know that they are part of a generation which, on average or exclusively or otherwise, doesn't drink milk.
Well, we say it's absolutely implicit. Once you got to the first point, you can get to the second.
yeah, but the reason why we're in a state of uncertainty, and maybe I'm making a misapprehension here, but let me ask you the question directly. I'm kind of inferring from the fact that it wasn't a ground of appeal to the High Court and isn't directly addressed by the hearing officer, that this wasn't an argument run before the hearing officer either. In other words, that when you were before the hearing officer, you didn't run the argument, even if point 5 is engaged, we escape because of the proviso.
I don't have my skeleton argument before me with respect to what was run in front of the registry. But from recollection, I'm fairly sure that we argued it was not a designation and that the whole matter was saved by point 6. So the focus was upon point 6.
Well, quite. Your argument was, and it remains part of your argument now. You say point 5 is narrow, and there's a good rational explanation for point 5 being narrow, you say, which is point 6 is broad. And so you say if we're not caught by point 6, that's an end of it, because point 5 isn't engaged in the first place. But then the question is, well, did you have a fallback argument to say, if contrary to your primary argument, point 5 has a broader application, nevertheless you can get out from underneath it because of the proviso?
Yes, my lord. I've just been reminded that I argued in front of, that must be the judge. So the skeleton is behind tab 12.
Right.
And the relevant paragraph is paragraph 27. It's page 103 of the bundle. This is where I use the milk-free example. Yes, it's the last sentence.
This is all in support of your argument that
Yes.
designation should be narrowly construed,
Yes, yes.
rather than an independent ground.
Yes, I can say with respect to the last sentence of paragraph 27 that that's probably as close as I get.
Yeah.
Yes.
Right, so I think where we've arrived at is this. We're not sure whether the point was run before the hearing officer or not.
I think
But-
it probably wasn't actually, but
You think probably not.
yes.
All right. Well,
Because I think we focused upon point 6 in front of the hearing officer.
Yeah.
I'd have to check that, but
Well, that would certainly
It's against it,
explain the tenor of the hearing officer's decision, because
Yes.
that's how she
Yeah,
deals with it. Yes. All right. Well, that's very fair. Thank you. So, I think, therefore, where that takes us to is that against that background, you need permission to raise this as a new point, having regard to those considerations.
in which case then, might I please ask for permission? The reason is that it is a pure point of law, doesn't require any new facts before this court, doesn't require this court to disturb any findings of fact below. Those are basically the points that are addressed in paragraph 34 of Voltif or something. I can't quite remember. VOLIT, or VOT, no, VOTIL. I can get the reference when I go back to Chambers.
Well, my Lord, Lord Justice Snowden gave one of the key decisions in this field, so he's quite
Fine.
well up to speed on
Yes,
the applicable
exactly.
principles.
My lord, are there other points in your decision that you'd like me to address?
Judgment, I
Sorry,
should say.
judgment, my
It
lord.
was a judgment of, he gave the lead judgment in one of the Court of Appeal cases. I should be clear what I mean.
Yes.
So it's a case called Notting Hill Finance and somebody else, Notting Hill Finance and I can't remember it. It's also referred to a decision called Singh and Das.
Yes.
There's two.
Yeah.
There's two. I mean, I sort of indicated that I thought there was a spectrum of cases, and at one end of the spectrum there would be cases where it was a pure point of law and the court could address it on the basis of the facts as found in the court below without any further investigation required. Which, given it, so long as there was adequate notice given to the other
Yes,
side,
yes.
so they weren't taken by surprise, etc., the court would be likely to say yes.
Well, that's against me here, the notice point.
Yeah, I mean, it depends how.
Yeah.
You know, but yeah. The other end of the spectrum is where there would be large-scale factual inquiries required, for example, after a trial.
Disclosure, recalling witnesses,
Exactly,
different
which
witnesses,
the
etc.
courts generally say no,
Yes.
and then there's a sort of big area in the middle which, infinite number of
Yes.
variants on a theme. But here, to pick up my lord's point, the remarks made by the hearing officer were not sort of directed at this question about whether any person would think that the words post-milk generation clearly described a characteristic quality of the product.
I have to accept that, my lord.
And so how would that normally be explored in a challenge to a trademark? Would it not be explored by some sort of evidence?
Well,
I mean, but by this, I mean, what I do know about trademark disputes and passing off disputes and intellectual property disputes is that people very frequently do bring forward evidence as to what surveys would tell you about how people view things. Is that the sort of evidence that would be required to satisfy this test or not?
well, my lord, you'll have noticed that this case is light on evidence.
Not complaining about that.
No. But the point was there was no evidence. And yet there was a finding under section 3.3b that the mark was not deceptive.
Well,
And
it depends what you mean by evidence. I mean, the hearing officer records that there was a witness statement before her, but it doesn't sound like it had much in it apart from exhibiting documents.
the witness statement was the vehicle for 3 documents, Tofu Town and I can't remember now what else, but it was all legislation or what have you. There was no actual evidence of facts as opposed to anything else. All that was exhibited could have been introduced just, the normal run of the mill by way of argument or an authorities bundle.
All right, but nevertheless, the point remains, of course, in the absence of evidence, the hearing officer would do what hearing officers always have to do, which is to use their own knowledge and experience as consumers, which is no doubt what she did with respect to 3.3b.
Yes.
But we don't even have her view.
No, I accept that. I'm left with the situation. I have no evidence. The 3.3b point was argued, in essence, in a vacuum, but it was argued in a way whereby she was satisfied that she could reach that conclusion. And in my submission, from...
Well, it's one of these points about burden of proof, really. I mean, she didn't analyse it in these terms, but the burden of proof was clearly upon the applicant for the declaration of invalidity to establish deceptiveness. They had no evidence, and she was not persuaded applying her own knowledge and experience as a consumer. By contrast, when it comes to relying upon the proviso, the burden of proof, I assume you would accept is upon you.
I thought you were going to ask me that, my lord. I think I have to because, of course, the burden of proof to show that I fall foul of section 3, subsection 4 is upon the applicant for a declaration of invalidity. But the proviso, so to speak, is in essence a defence, and under the general principles it's for the person that's relying upon a particular proviso to make good their case. So for that proviso element, it would appear, if not legally, certainly evidentially, the burden would fall upon me. So I have to accede to that, my lord.
So the curiosity of this is, just coming at it sort of, again, a little afresh. I understand why young people would buy a t-shirt with post-milk generation on. In fact, some older members of the older generation might buy one in a failed attempt, no doubt, to appear cool. But I'm not so sure what post-milk generation, without any hyphens, tells you. I mean, is it that what's in the container comes after it was generated, as Mr. Moody Smith suggested, by the cow? Or is it post-hyphen milk, which it isn't, generation? What's the, we could get in, it's a good slogan, but it's not exactly clear what it's telling you.
My lord is prefiguring the argument on non-use if you survive this challenge.
My lord, do you mind if I decline to take that poison chalice and leave that for another day? What I was going to say to my Lord Justice Snowden's point is that with respect to the hyphen, I would say that is merely a grammatical usage that would make even clearer the meaning of the unhyphened three-word phrase, because that would emphasize the proximity of the words post and milk. Now that might be convenient.
Yeah, if it was hyphenated, might slightly more strongly suggest that you won't find milk in it.
Yes, I accept that.
But if you don't hyphenate it, which it isn't, I say it is still sufficiently
clear that the mark is speaking to the relevant consumer, that this is a product that satisfies the wishes and desires of that particular cohort of consumers. And by necessary implication, that can only occur if the product itself is milk-free, because otherwise it would be deceptive. If it didn't speak to the consumer, it'd be basically saying, we're milk-free, but actually we have milk in it. The sign doesn't say that. The sign basically says, we're speaking to the consumers who do not wish to consume dairy.
You could put post-milk generation on anything and appeal to a particular young generation, if that's what's apparently what it signifies.
Well, in essence, the class 25 use on T-shirts is that sort of merchandising type.
But why does it say there's no milk in it? It just means all you're actually saying is, young people, you should buy this.
Yes, I see your point.
So you could have a good class 12 registration, for example.
My lord. But with respect to the use of that mark with respect to the food classes, 29 and 30, what have you, that can only be not deceptive if the message it conveys is that there is no milk in those products.
Well, no. That's surely the point that the hearing officer made. Let's take the assumption, which is not what she found, but it's a good way of testing the argument, that it's meaningless. If it's meaningless, it's not deceptive.
Yeah, but she didn't hold that the phrase was meaningless.
No, she didn't. But if you read it the way my lord was suggesting to you earlier, namely as a statement about the consumer, not about the product, then it can't be misleading as to the product.
Well, if the mark, I think the point being though is that the mark for which one is seeking registration, if it were in respect of T-shirts and things like that, which it is as well, class 25, then that could just be in essence a political statement or a statement of intent. But you put that to one side. The mark was also found not to be deceptive with respect to the food classes. And so therefore, if it spoke to the consumer falsely that those things contained milk, then you wouldn't get over the 3.3b hurdle.
Could you use it on something that was, as it were, reduced milk or reduced dairy?
No, it's the same answer, my lord, because the point being is that it's a statement which is not saying, that's not understood as saying this only has a little bit of milk in or some sort of adulterated milk in.
Well, except, I mean, there's lots of people who presumably out there who don't. I mean, some people don't drink milk because it doesn't agree with them.
Yes.
There are some people who don't drink milk, presumably because they don't want to encourage, the production of methane gas
Yes.
from milk-producing cows and
Whatever.
ruin the
Yes.
climate,
Yes.
or not, depending on your point of view. And so, the reasons why a consumer might buy something that says post-milk generation on it doesn't necessarily connote that they think that it has no milk in it. It could have a reduced amount of milk. It could just support their personal aspirations.
My lord, yes. But in essence, what now one is trying to do is to read into a 3-word trademark a whole thesis on consumer consumption with respect to dairy products, whereas the simple direct message is that it has no milk in it.
Right. Well, I mean, in a sense, we're probably just going to come back to that simple question: either you're right about that or not. And you
Well,
say,
that's all I can say in any event, my lord, sir.
but you presumably just say that this court can decide whether it does clearly say that or not,
Yes.
because the hearing officer seems to have done it without the benefit of any evidence.
Yes.
So you just say, well, okay, there's no difference for this court doing it in quite the same way she did.
Exactly. That's why I should be allowed, if I need to amend so as to raise this point, which addresses your point about evidence, which is where this particular argument starts.
So we started
I think.
all of this because you took us quite rightly to paragraphs 33 and 34 of Tofu Town, and what that has in fact led to is an extensive discussion of your respondent's notice. And it's our fault for taking you out of your way.
No, my lord.
But is there anything else in Tofu Town that you would like to address?
I think I have exhausted Tofu Town.
Right.
What I was going to, in some senses rather embarrassingly, was actually to take you to the regulation in question, if I might.
Certainly.
And it's behind tab 6, and the relevant bit starts at page 151. And to put you in context, what we're looking at is part 3 of Annex 7 of the new regulation. And if you turn the page to page 152, you get to point 5. And this starts off with saying the designations referred to in points 1, 2 and 3. So therefore, there must be designations in points 1, 2 and 3, otherwise that doesn't make sense. But there was a point raised that milk was a term as opposed to a designation. But if you look at the second paragraph of point 6, it does say, well, the first point I say is that actually that must be wrong, because otherwise the opening words to point 5 don't make sense. Milk must be included as a designation. But this is put beyond doubt, I say, in the second paragraph of point 6, which says, however, in respect of a product which contains milk or milk products, the designation milk, or the designations referred to in the second subparagraph of points 2. So clearly milk itself is a designation.
I apologise, I didn't follow the reference. Could you repeat
sorry,
that?
Yeah. I was talking on page 152 of the bundle.
Oh, the designation milk. Yes, okay.
Oh, you've got it. Sorry, yes. Now,
thank you.
It's the second paragraph in point 6. So the point there is that yes, milk is a defined term, but it's also a designation. And I say that in 2 different ways because of the introductory words to point 5 and the wording in paragraph 2 of point 6. Then reverting to point 5, this deals partly with the Tofu Town point on paragraphs 33 and 34, which is if you're against me and that post-milk generation is a designation, then I say it does fall within the second part of the proviso in point 5. and for the reasons that we've been through, and I don't need to go through again. But the point that Tofu Town limits exclusively and exhaustively everything that would be permitted under the proviso to point 5, I say can't be the correct interpretation of Tofu Town paragraphs 33 and 34, because otherwise phrases like milk-free would not be permitted. And I say that can't be the correct interpretation of the way in which you look at Tofu Town and how it interacts with this. And I use that in support of the fact that Tofu Town is really concerned with the first part of the proviso to point 5, apologies.
I mean, you presumably agree, you presumably say that the use of the expression milk-free must be permitted.
Yes.
Because,
Assuming it's on a product that is milk-free, you must be permitted to tell the truth.
and say milk-free, and actually sell it as such.
And not only milk-free would be a designation, I would say, of the product, but it must be a permitted designation.
Yeah.
And the fact that it contains the word milk, you can't salami chop, so to speak, a composite phrase so that you are left with the word milk and somehow say that that is therefore banned. You must look at the phrase or the composite terminology as a complete whole. And that's why post-milk generation must be looked at as a complete whole. You can't just get rid of post and generation. That's artificial and wrong. You must look at it as a combined whole. And that's how I run the argument that when looked at as a whole, I get in under the second part of the proviso to point 5. And that also then leads me into the second ground of appeal, which is, the long and short of it is, that you can't distort post-milk generation in such a way that you reduce to nothing the post and the generation. So
that
that
wouldn't be notional fair use.
Yeah, exactly. It's not notional fair use. And the hearing officer spoke about that. That was in the paragraph to which I took you in the decision. That the average consumer wouldn't ignore the post and the generation part of the post-milk generation bit. I think ground 2 just falls away because it's not notional fair use. It's as simple as that. The respondent's notice, there's really not much more I want to say other than that which is in the skeleton. And with respect to the construction, I know my Lord Justice Arnold has said we haven't conducted an extensive analysis of all the various languages, but it is a side point on the respondent's notice. And therefore, the proportional approach, I would say, would be for me to look at things which I could read, as opposed to going into all the other languages which I couldn't. And that's why, on reflection, I favoured the two-part analysis.
What about the second aspect of the notional fair use? I mean, I take your point as to it's not notional fair use to emphasise the word milk out of the composite phrase. I understand that. But the second aspect that's relied upon is that it will be within notional fair use to put the class 30, 29, 30 and 32 products bearing the trademark next to dairy milk products on the shelf. What do you say about that?
Sorry, the Oatly products next door to dairy milk
products.
Yeah.
Well, they're usually, I mean, they are very often to be found next to the dairy products.
Well, yes, depends which supermarket you're going to, but yes, sometimes
Well, they are in mine anyway.
Yeah, a group of dairy milk products, group of non-dairy milk products.
Yeah.
Well, the point about that is that actually then you have a clear positioning of the products before the consumer, and so therefore they will actually pay attention to what they're doing. If you're positioning post-milk generation branded products in a block next door to dairy milk products, then the normal consumer will see that there's product A and product B and make a comparison and pay some attention. You're not looking at somebody who's in a hurry, or somebody who is not taking any particular attention. The whole purpose of the normal consumer with respect to these sorts of considerations is taken as somebody who has a reasonable degree of care and consideration and attention.
Okay.
So I wasn't going to belabor the point about the respondent's notice, because I think what I've said in the skeleton says it all, and my learned friend and I are not that far apart anyway upon the construction point, partly because he says I lose either way around, and I say also I win either way around, so
Yes.
it's pinheads argument. That's why not much time was spent on it. It's just I thought I'd bring it to your attention that I had actually looked at the Spanish version.
Yeah. All right. Thank you.
Any other questions from anybody else?
Yeah. Thank you
In
very
which
much.
case, my lord, thank you.
My lords, very briefly, if I may. First, my learned friend's application for permission to run a point on appeal that he didn't run below. How he seeks to get that point off the ground, my submission is that he shouldn't be given permission to amend to do this, or at least not without one important condition. How he seeks to get his point off the ground is to say, because I haven't challenged the finding of the hearing officer in relation to deceptiveness, which I don't, but what she says about the meaning of the mark to the average consumer in that section, because he says I don't challenge that, therefore he builds on that foundation to say this means it's clearly, it describes the characteristic of the goods. If that were a point that had been run, and were being run on this appeal, or had been run on the court below, then I would have sought to challenge that finding of the hearing officer in terms of what the average consumer would see by post-milk generation. Because in my submission, it doesn't matter because it's confined to the deceptive aspect of that. But if the gloves are off on that, then rather than merely post-milk generation could be the state of the cow, it could be a young, my own friend refers to the age of consumers, the youth of today. It could be those who are old enough to have been weaned. They are a generation that are post-milk in terms of things. It could refer to all manner of things.
Post bottles of milk at school.
Well, precisely. It could be all manner of things, and it wasn't canvassed before the hearing officer because it wasn't material at that stage. And I have not. I've had my hands somewhat tied because I don't challenge that finding. But if my learned friend says we're free to have a go on this, then I would, and you're probably happy to be spared this, but I would have spent quite some time coming up with things that post-milk generation.
I think what he might say is that actually he accepts the point wasn't run as such. So let's put out of the way his reliance for a minute on the findings in relation to deceptiveness. Nobody adduced any evidence about whether it was, quote, clearly used to describe a characteristic quality of the product. And on the face of it, I think he'd say, well, why can't this court do it in the same way as anybody else? You just form a view as to whether those three words clearly describe the fact that this product has no milk in it.
Well, that is the rub of it, because those three words on the meaning that the hearing officer ascribed to them, my learned friend says they then clearly denote something that is, because it's not deceptive, it must not have milk, therefore that is a characteristic of the product. If that is to be argued, then, and as a tribunal, your lordships can address it afresh and say, well, these three words, what do they mean? What do I think they mean? My submission is they do not, putting to one side the hearing officer's consideration, they do not clearly designate, they don't clearly describe a characteristic of the product. Post-milk generation, it refers to the consumer. It doesn't refer at all to what's in the product. And even if it did, you get there through some crossword, Rebus-like approach to an analysis, it's not clear in any sense. And this is where my Lord Justice Arnold's question about burden of proof feeds in, less on a strict burden, though it is for my learned friend to prove that he falls within a proviso, and it's for me to prove that something is deceptive. But it's a question of a hearing officer can look at something and say, well, this slogan is not clear one way or the other. It gives the general impression it's not deceptive. And so it doesn't fall within the scope of that part of it. But it doesn't clearly describe a characteristic of the product either. It's not clear at all. And that's no criticism. Slogans don't have to be clear. They can mean what they mean to each particular consumer. But my learned friend has to establish, for within the proviso, that it clearly describes a characteristic of the product. And he's just not there. So in my submission, no permission to amend to run this, but if I don't push this strongly, I don't wish to spend a lot of time on it, but if you are to look at it afresh, then look at it afresh without the straitjacket of the hearing officer's finding as to what post-milk generation, with or without a hyphen, might have meant to the average consumer. So it's what I do object to is the learned friend saying, well, you're bound by this finding because you haven't challenged it, therefore you have to sit quietly while I draw a conclusion that it simply won't bear. That was the first point I had. The second point is again quite a short one. When your lordships were questioning my learned friend about milk-free, I think he said that he thought milk-free was a designation. Now, it is, on my case, milk-free is a designation. It's something about the nature of the product. It's not the name. You can't go into a shop and say, can I have 24 milk-free, please? It's not a designation in the sense that he...
I think, to be fair, I think he would, unless I've misremembered it, I think that exchange was said in the context of this second line of under 5.2, when we already assumed that he's lost on the first point. I think. I mean, I could be wrong.
Well, my lord,
I seem to remember that. I didn't think he'd just given up his first point
my lord,
by accident.
My lord, I'm not saying, but I am. My lord, if that's a fair way of listening, then of course it's open to him, because an advocate can argue things on all manner of assumptions, and it did come within that part of the argument.
Well, but I wrote down milk-free as a designation, so I think your note of his submission is accurate. Yeah. But, and my lord is right that was the context, but I don't think it necessarily damages his argument on point 5 anyway, because what the judge said, and Mr. Edinburgh supports this, is that designation connotes a generic description of the product. Now, if that's right, why would that not encompass milk-free?
My lord, on that basis, your lordship's absolutely right. My understanding of the judge's reasoning and my learned friend's case goes beyond something being a generic description of some aspect of a product. It is the name. And that's where, so this is the final point I was going to address your lordships on.
So, sorry to interrupt you, let me parse that and see if I've understood what you're saying. So you're saying the force of this point is not so much that it undermines the final conclusion, but you say it undermines a key building block in the argument.
My lord, yes, because it undermines the key building block of my learned friend's submissions and the judge's reasoning, which is to say two things, 2 points in this. One is that designation means the name used at all stages of marketing. That's what he says the definition. You remember that the submissions on how Annex 7 must be read in the light of the definition in Annex 12, and so you import that in. So he says you read it in that way. because he's importing the definition across from Annex 12, which says designation, means this. And the second limb of his submission, which is that why it's important that a designation means the name, generic, of a product, is that to rely on those, the regulation, the directive concerning product naming, which say that it's not permissible to replace the name of a product with a brand name, trademark, or fancy word. If he loses on either of those, so those two together then say, well, this means that designation is not a trademark, therefore, ta-da, I am free. It says it's all fine, post-hoc generation is okay. If he loses on either of those, the argument falls down, because if designation means a name, but a name doesn't exclude a trademark, then he's not there. And similarly, if names exclude trademarks, but designations are not limited to names, then again, he doesn't get that. And in my submission, his concession, his statement, what he said in argument, cuts across that associate the requirement within his argument to say that a designation must mean the generic name of a product rather than merely some description of a characteristic. That's my case, is that a designation is any description of a characteristic. Now, those two limbs of his submission, the first was, he argued before your lordships that because the structure and the words within Part 3 of Annex 7 to the new regulation are essentially substantively the same as some of, not the definitive part, but some of the aspects of Annex 12 to the earlier regulation. He says, therefore, one must import the definition of designation from the earlier Annex 12 into Annex 7. He says it would be wrong to do this for the meaning of words to change. Just as an aside, the meaning of words in legislation often, especially in a European context, can change. One can think of the InfoSoc directive and the definition of substantial part in terms of the meaning of infringement. If one's looking at it and think, well, the meaning of this term has changed as a result of some directive that now says we have to, the word stays the same, but the meaning has shifted.
Yeah, well, that's my leasing. That's a different point.
My lord, it is, but it's a but more importantly within this is the definition within Annex 12 to the earlier regulation was limited only of sales of designation, to mean that the name used at all stages of marketing was limited to that annex. The definition of sales description, meaning the name, is everything within the part. It extends beyond, not just Part 3, it's all manner of different goods. And so if one reads designation as having the meaning under Annex 12 in the early version, and says that's how designation has to be read, the name used at all stages of marketing, then one is importing that meaning from a milk-specific context into every single other aspect of the goods that are under the other parts of what is now Annex 7. And so designation within the context of meat must then have a meaning that is derived from, Malone Friend says, a previous provision that was limited only to milk. And you can see, just by way of example, you can see that happening. If one looks at 143, which is where we've been looking at the Annex 7, it starts off with meat and defines, so page 143 behind tab 6, when one's looking at the meat of bovine animals, sales descriptions under Roman 3, sales description of the meat of bovine animals less than 12 months, and you've got less than 8 months, various forms of veal, and then under B, 8 months to 12 months, other forms of veal, or in this country, just plain beef, one sees at 145. So these are the sales descriptions, And then at 2, the sales descriptions referred to in paragraph 1, so this is at page 1452, sales description referred to in paragraph 1 may be supplemented by an indication of the name or designation of the pieces of meat or offal concerned. So just looking there, one then has to take designation, which is said to be the name used at all points of marketing, and use that to modify or add to the sales description, which is the use of the name at a particular point of marketing. It leads to tension and confusion.
You say designation means description.
It means a designation is a description of some
Right. I mean,
some quality.
A point which I hadn't spotted before until you just asked us to look at it again. I mean, if you actually look at the Commission decision, and I'm not going to go into the argument we had before, but that actually uses the word description as synonymous with designation, doesn't it?
My lord, it does, but this is...
Because it does, when it describes the regulation we've just been looking at in recital 2, it says, as an exception, this principle is not applicable to the description of products, the exact nature of which is known because of traditional use. But in fact, the wording is, this provision shall not apply to the designation of products, the exact nature of which is clear. I mean,
but that's the 2013 regulation. One would need to compare the same wording in the 2007 regulation.
Is that right?
Okay. So the 20...
Hang on. Yes, you're quite right.
That'll be the 2000 and...
My lord, it's against me, but if you go to the 2007...
I thought it was description. I thought it was designation and designation.
Yeah, it's on page 29.
Definitions and 28, 29.
29.
The designation means...
Yeah, because I thought your point was it was directly copied across, and it's designation and designation. Is that right?
Designation means...
It is designation, yes.
It is designation.
But
so the point still holds good.
Sorry, I'd only just sort of spotted that when you just drew our attention to it again.
But this is... So just standing back, this is a... This process of sort of lexicographical archaeology we're looking at, picking over and trying to see what words are used in what context, one only gets into this difficulty of defining boundaries of what happens at peculiar edge conditions if one takes designation and seeks to give it this specific term that my learned friend relies on. That's where all of the trouble flows from. And that's why one might see the CJU in Tovertown not engaging with whether a designation is a trademark or not. They don't engage directly because it's only if you come up with the idea that it becomes relevant. If that's how you're going to run the case. And it's my learned friend's case that he needs to succeed on to say that designation cannot be the same thing as it is a name for a product, but it cannot be its brand name. It excludes a mark. Which brings me on to my final point, which is of the two limbs. I said my learned friend needs to get home on the definition of designation expanding beyond the original Annex 12 and governing the whole of the new Annex 7. But he also needs to get home on saying that because in the marketing, the product naming regulations, it's forbidden to replace a name with a trademark, so a designation in his case with a trademark, brand name or fancy name. That means that those two are distinct. And that logically simply does not follow. One is saying on a packet, you can't replace this designation, his assumption, it's a product name with a brand name. Well, that makes sense. You can't do it. It's not good for certainty in the market. There's all manner of reasons why you can do it. But that doesn't then mean that nowhere shall a designation be read to cover a trademark. It goes far too far. It doesn't support that weight and would lead to what in my submission is the absurd consequence of a key piece of control of marketing usage, the uses of definitions, designations and sales descriptions in marketing, somehow excluding any use that's in a trademark. which is the consequence of my learned friend's submissions. And so it's an ingenious argument, but, my lords, it simply doesn't get the learned friend home. Lords, unless there's anything I can assist you with further, those are my submissions.
My lord, I was
Yes,
just going to say, those behind me have looked at my skeleton from the registry, and they've confirmed what I said, which was that I did not mention the point 5 proviso argument. So that deals with that point now, as opposed to me going home and finding it.
Thank you for that confirmation.
Does he want to just deal with that, say anything about that descriptions point that I just made?
Do you want to say anything about the Commission decision and what Lord Justice Snowden pointed out to us about the wording of that?
Basically, no. He says there's why they've used the word description there as opposed to designation is a mystery to me, and there's nothing I can really take it further. So,
Could we just use loose use of language in an instrument that was presumably drafted in French and then translated, and that can lead to all kinds of problems.
And it's the recital in any event, as opposed to the actual substantive operative parts. But I think we've been going around in circles enough with respect to descriptions, designations, definitions, and sales descriptions to not trouble you further.
Indeed, quite so. Very good. Well, thank you both for your submissions, which have done their best to shed light on a corner of the law which is not terribly clear, it must be said, and therefore we will certainly not be giving you a decision today. On the contrary, this is clearly something that requires some thought, and we will therefore be reserving our judgments. I'm not going to make any promises as to when you will get them. We will endeavour, if we can, to get them out before Christmas, but it's in the nature of life that it's not always easy to do that. So forgive us if it's not until the new year. As I'm sure you both well know, you will be sent a draft in advance of the decision being made public for the purposes of correcting typographical errors, obvious factual mistakes and things of that kind, but not for the purpose of re-arguing the case. Please notify to us any such errors, and if you can, agree a consequential order. If not, please provide brief written submissions as to what would be the appropriate consequential order, and we will decide that on paper. No further attendance will be required, and the decision will be handed down digitally. And in the intervening period, as you well know, it's subject to embargo, and the embargo must be strictly observed. Thank you again.
Court rises.